One thing I've been very happy to see over the course of the 3 years I've been doing the Great Divorce podcast is that more people are aware that there are different ways to get divorced. There are alternatives to what I call the divorce industrial complex. The stereotypical marital warfare where you have pit bull attorneys fighting it out in court. Kind of like that TV show from back in the day, LA Law, if you remember that. Regular listeners to the podcast will have heard me discuss how mediation works. You will have also heard me discuss the formal process known as amicable divorce and how it compares in contrast to another formal process known as collaborative divorce, which has been around a little bit longer. If you want a refresher, please go back and listen to episodes 5 and 58, where I discussed mediation, and episode 20, where we dove into amicable divorce. Well, my guest today is the founder of another process, which is an alternative to litigation. Amanda Mason is a highly experienced divorce attorney, graduated from University of Arizona Law School in 2003. A litigator from the start, she spent most of her years practicing in the traditional family court system. Having seen firsthand how damaging that system is, she set out 6 years ago to develop a new method for divorcing couples to resolve their differences. Today, that method is known as the Solagree model, which is increasingly being adopted around the country. Amanda explains that Solagree is the only method that provides predictability of time and pricing while assuring couples they will never go to court to resolve their disputes. This is accomplished using binding arbitration at the end of phased efforts of agreement, rather than a judge. Well, Amanda, I look forward to hearing all about Solagree. Welcome to the Great Divorce Podcast.
Thank you. Thank you for having me. Appreciate the introduction.
Very happy to have you here today, Amanda. Before we get started delving into the specifics of the Solagree process, tell us a little bit about yourself and how you came to develop this alternative to the traditional family court system for divorce.
Yeah, so as you said, I've been a litigator for a lot of years, more years than I like to admit to, but hearing that 2003 seems like a long time ago now. Um, I was a litigator throughout my law practice. I enjoyed litigation. I thought it was fun until I started to realize the toll it was taking on people in the family law context. So litigation is a really great tool for things where we really need to divide and conquer for where you have, for example, I did some criminal work for a while in federal court, and I thought it was great for that. I thought the truth really could rise to the top in that kind of setting. But I did not feel that way in my family practice. In fact, I felt it was antithetical against the goals of having couples come out of things, relatively healthy, forward-looking, unscathed. And this all came to a real head for me when I noticed, when I had my own custody trial. So I'm one of those attorneys who's been through the whole thing, and I actually took the stand in my own case. I had been a practicing attorney for many years at that point. I'm glad to say this has been many years since then because it's a trauma. I understood very well what the system was. I understood procedure. I understood the law. This was a courtroom I had been in my entire career, quite literally. And yet I felt all of the anxiety. I felt all of the fear. And I had, as far as trials go, not the worst experience that couples have, but it still was just awful. And then as my practice continued, I just continued to see more and more problems with the system, with the ability for, and this is really the key, the ability for one person in the whole process. It could be an attorney, it could be a judge, it could be either one of the couple, having the ability to just blow the whole thing up, make it drag out for years, make it cost tens and tens of thousands of dollars, the thing that you see on TV. And so I felt in my heart I could do better, and I knew in my head I could do better. And so that's when I started working on the model that we're discussing today.
No, that's terrific. And I think your backstory is similar to a number of us divorce professionals in the financial realm as well,
Yeah.
where we went through the process the traditional way and realize there's got to be a better way,
Gotta be. Yeah.
and have endeavored to find meaning and purpose in what we do, helping people with alternatives to that process.
Exactly. No question about it. No, no profession is immune to it. And, once you see how bad it can be, and you have a skill set that is relevant to divorcing couples, it's almost like you just have to do something.
So I've visited the Solagree.com website, and we can get into the fact that I've actually been involved in a few Solagree cases as a professional also. But what jumps out at me, the headlines: virtual, flat fee, fast. Can you give us a 30,000 foot overview of how Solagree works?
Right. Okay. So the basic is there's three steps. There's three basic steps to our process. Step one is our intake phase. That's where our couples are going to work with someone like yourself, a CDFA, certified divorce financial analyst, on the financial side. On the parenting track, they work with one of our custody intake specialists. So these are people who are going to help them create their parenting plan. With that early phase, we are already educating people about the options. We are giving them the opportunity to design their own outcomes. They're being transparent and they're developing trust with each other. In phase two, it's a mediation. So there are mediations available in lots of contexts in the law. Our mediations are structured around the way we do the Solagree method, but the goal is still the same. It's to get people to resolve matters for themselves with the help of a neutral third party. And then at the end of the day, they go to an arbitration. Everything they've agreed upon is incorporated into the arbitration award, is what the document is called in most states. And anything that they still haven't been able to resolve for themselves, the arbitrator will solve. So it's an informal, flexible way for people to resolve their differences. As for the virtual component, yes, everything that we do in Solagree is virtual. It is the one silver lining to modern technology being adapted to that awful virus we don't speak about is people understand that the virtual world can really work, keep them in their safe space, and allow them to get a lot done in the process. This is important because yes, I want them in their safe space, but it also allows me to streamline the process for them so that they can save money, which is extremely helpful by putting them together with professionals wherever those professionals may be. So yes, three steps virtual, and we keep it moving. We don't allow any one party to just drag it on, and we don't have to wait on court dockets.
It's great that it can be done from the comfort of a Zoom call in your home or your home office. It's less intimidating than being in an attorney's office or certainly a courtroom. So there's an element of comfort there for sure. You mentioned flat fee. How does that work?
So depending on a couple's state where they are, so everything still has to be based on state law. We can't get around that, but we are able to structure a flat fee payment program in three phases to allow the couple to fan out their payments. This is going to be a flat fee that costs much, much less than what a standard divorce that's litigated is going to cost. And quite frankly, it costs less than I would have even charged for a separation agreement when I was full-time practicing law. The goal is for people to have that predictability. Everything that we're doing is designed to have predictability and give people relaxation in the process so that they don't have anxiety. And the way that benefits couples in the process is that they're no longer in their fight or flight mode. They're able to think with their rational brains. That helps them guide decision making, not based on just raw emotions, which is easy to just not only come into play when you're first learning about the divorce and what you're going to be experiencing, but at any point in the way that can drive back up. So yeah, flat fees are really at the cornerstone of this. We want people to know exactly what they're paying for up front.
Okay, so you mentioned the intake process, which I mean, I think it's great that it's a CDFA, such as myself, certified divorce financial analyst, gathering all the financials together, making it easier for the mediator in the next step to see the complete picture of the marital balance sheets. And I know as a divorce financial analyst, I'm always encouraged to if I can find as many points of agreement as possible and save work for the mediator in the next step, then that's kind of an element of pride I like to place in the process, and I think a lot of CDFAs are probably like that as well. But when we get to the mediator, is the mediator an attorney? And if we move to the next step, the third step, the arbitrator, is the arbitrator always a necessary step or only if mediation doesn't work? And is the arbitrator an attorney or a former judge? How does that work?
Yeah, good question. So the mediators that we we appoint in these cases are all attorneys. And they are attorneys who have a lot of experience in family law. The arbitrators, same thing. They are attorneys within the same state as the parties so that they're familiar with the state law. It is our belief that most cases should go to arbitration, even if there is a complete agreement in mediation, because that's where the binding arbitration, the binding document, the glue is
Okay.
created for the couple. So it's always a question. We have to figure out what is that final piece going to be that actually holds the couple to the agreement, because divorcing couples aren't really great at just shaking hands and agreeing to agree. So we give them an opportunity to have a binding document created by one person, a neutral, rather than have the document created by two different individuals, meaning their attorneys representing each of them.
Okay, so let's go back to the attorneys then. So the mediator attorney is a neutral. They can't
Yes.
provide advice to the parties in the divorce. How well, they can, you tell me. As far as I understand it, they can interpret the law, but they can't necessarily provide advice. What if the parties say, I really like to have an advising attorney here, or just run this past a legal expert? How do attorneys fit into the process?
Yes, we definitely love working with attorneys in the process. One of the reasons why I developed this was I said, this practice of law in this way is not fun. I'm sure I'm making plenty of money at it. It is lucrative for attorneys, but this is not an enjoyable way to go about this. So I wanted to give a gift to attorneys to where they could bring their clients through a much better, much softer framework where they could scale their practices, represent more people in a more efficient way, and go home at the end of the day knowing they'd done a good job, their clients were satisfied and got an efficient result. So we have a couple of different roles. We have an advising attorney, which is what you were referencing earlier. That's going to be someone who's essentially a behind the scenes consultant in the process. They're going to give a flat fee to the clients. The clients are going to know exactly what they're going to pay, and they're going to guide them through. Hey, make sure that Andrew, your CDFA, knows this piece of information when you're talking to him about the value of the marital residence. And then, okay, now when you go to the mediation, make sure the mediator knows this and that, and make sure that you don't forget these important details. And then, okay, we got the mediation summary going. Here's what you need to make sure that you have packaged and presented to the arbitrator for this one remaining issue that you weren't able to resolve in mediation, right? So it's a behind the scenes process. Again, flat fee gives that predictability. There are some cases that are more complex. And in those circumstances, we recommend that the couples hire what we call an appearing attorney. This is an attorney that they're going to pay at an hourly rate, just like you would pay if they were going to court, but they're going to appear on your behalf and represent you during the process. The goal there is to still have all of the tools available to you that you would have had in a courtroom. And we do. Every single thing is available to you other than a specific judge. But nonetheless, have a more efficient process that has a guardrail in terms of timing and efficiency, which is what the arbitration itself provides. The arbitrators themselves, we vet, I want to make this abundantly clear. We make sure that these are people who have the skill set to do the work. We make sure that they have the background in family law to do this work, which a lot of judges taking the bench do not, and that they have the agreement that they're going to treat all of our clients and the attorneys appearing with them with the utmost of respect. Because if they don't, we're going to hear about it and we simply won't hire them again.
No, that's very important. So you mentioned, potentially adding on an attorney to if for a more complex case. What about more if there's issues like a business, for instance, that needs to be valued, business valuation experts, property tracing, this sort of thing. This has all got to go as things get more complex, there have to be add-ons beyond the flat fee, I assume.
That's right. And we work with a network of professionals who can provide those services. Of course, if a couple has someone that they want to go to, we're not going to turn that person away. But usually people just don't have that tool bag full of those professionals ready to go.
Right.
So yes, we work with a great network of people who can provide that business valuation. The couple could say, let's see what this person says. If the husband doesn't like that valuation, how it comes out, he would still have the opportunity to go and get his own business valuation done. We're not trying to limit the options of what people can add on to the process in terms of adding valuable resources to the process. We're just trying to set those guardrails in place so that, again, no one person can blow the whole thing up and make it more
Right.
costly and time consuming than it needs to be.
No, that's terrific. I'm wondering, is there an ideal client for the Solagree process, or can it work for anybody?
Solagree can work for almost anybody who has a dispute about or has issues to be resolved. I don't like the word dispute, has issues to be resolved about their finances or their parenting matters. So, really, truly, yes, people who are amicable, and I love the word amicable, it's an important word in our vocabularies. We like to get there. Yes, amicable couples are great, but we are here for non-amicable couples who know that they just don't want to give up all of this time. They don't want to give up all of their money. They don't want to give up control of the process to someone else. So they come to us and we can assure them they'll get it done in a more efficient manner.
One of the key issues, you've probably heard the old statement that the criminal justice system sees bad people on their best behavior. The fellow with the tattoo on his
Yes,
forehead, but he's all dressed in a suit and tie and he's being very polite to the
that's
judge.
it.
Whereas the family law system tends to see good people on their worst behavior because, and I think a lot of this, and I think you'd agree, a lot of this is because the type of system that they get sucked into, they get involved, they get sucked into this litigious process, and they may have pit bull attorneys who are, you know, saying bad things about their soon to be ex and throwing fuel on the fire.
Yeah.
You know, these people get sucked into, the divorce industrial complex, as I call it. I'm thinking that the best time for people to adopt the Solagree process is to try and get in it at the outset. No?
I mean, absolutely. If we can get them early on before quite frankly, some of my former colleagues get to the case and start spinning and spinning. And listen, I don't mean to talk ill of attorneys. It is exactly what you're talking about. It's a divorce industrial complex. It's the system, and attorneys are trained in that system, which is adversarial. It's someone versus someone. The earlier we can get to couples in that process, the more we can dial down the anxiety at the outset and have them thinking more positively. So, from the standpoint of that's the earliest point that we can help save them from the divorce industrial complex. I love that. I'm going to use that all the time. Yes, early is better. That said, we can pick up at any point. I mean, truly, until they're standing in a courtroom at trial, we could theoretically take over and get them onto a better path. Wherever they are, we'll meet them.
That was my next question because, I've certainly come across couples who've already begun the process, and you can sense that they may be having regrets, that they weren't entirely amicable, but they weren't at each other's throats either. And ultimately, the process may have led them down a path where it's become very contentious. There's still a way out, is what you're saying. They can still adopt the Solagree process.
Yeah, absolutely. And one thing too, I asked my attorneys, take a look at your cases and see which cases are stuck because they can come to us. You can bring them to us. We will tell them what a wonderful job you've done and help your clients out of this more quickly. It's easy for a case to get caught up in the system for whatever reason. There are cases that just don't make calendars, they're not on the docket. Things that are beyond an attorney's control a lot of time just happen. During that waiting period, couples find things to fight about. They find more issues to be upset with each other about. And why? It's the helplessness and it's the lack of control. And if you could find someone to blame or something to be upset about, then that's you finding some outlet for your lack of productivity and control. So yes, absolutely. We could take over, and the attorneys can remain involved if you like your attorneys. I always say you have to kind of like your divorce attorney. You don't have to like your criminal defense attorney or your real estate attorney, but it's so personal. So we don't want to, send you away from someone that you have a good relationship with.
That element of speed of the process is so important because, as you're saying, many times attorneys will have very full caseloads. They and a lot of clients have unreasonable expectations about how quickly the attorney will get
True
back to
that.
them.
That's absolutely true.
And but regardless, that time can have and people's imaginations will start to fester and they'll start to think of all sorts of potential calamities and take people down the down a spiral, so to say. So if we've got a process that can potentially avoid that spiral, that can only be a good thing.
Yeah, very well said. And you're looking for ghosts too, right? So what did he mean during that custody exchange when he said I look nice today? What did he mean? Is that a trap? Is that a trick? Is he trying to get something out of me? Is this going to harm me in court if I all of those things? And it's natural human behavior. It is again, it goes back to fight or flight response
Yes,
because that's what
the
you're
saber-toothed
in.
tiger around the corner. Yeah.
It is. It is. It cannot be helped. The smartest people, the savviest, most accomplished people cannot help but have those thoughts and those experiences. So again, we want to get them out of this. And there's the key, Andrew, that I'm not sure is really clear about why arbitration works so well. When our couples know from the outset that at the end of this process, even if they can't get to 100% agreement, they're going to have a nice soft landing pad to get this done, they're already pulling out of that natural response. And that's what the arbitration kicker does. It promises each other, whatever happens here, we're not going to let this make the worst of us. We are going to get this done efficiently. And that's a gift to ourselves, it's a gift to our children, all of our family. It really is, it's fascinating to watch the distinction between how cases come through this process versus how cases go through any of the other processes that exist.
Right. You mentioned efficiently, certainly financially and emotionally, because as people who've experienced the traditional court system go, is that there's a ramping up for trial, and the costs start to accelerate, the emotions start to accelerate. As you say, when you've got that ramp to the arbitrator, a lot of those issues are to the side.
Yeah, that's right. Yeah, the cost of going to trial cannot be understated. It's crazy. I just wrapped up one of my remaining cases. I had 32 gigantic trial binders prepared. I mean, that took forever. That was so expensive to the client, and we ended up settling, of course, at the last minute. But
Hmm.
it's too much, and that's what happens. You don't get the other attorney's attention to the case until the eve of trial. Sometimes they're not focused on getting to a settlement. All of these things are related to that one person principle. As long as one person can blow the thing up, there's so much risk at play.
Right. I'm curious, what challenges have you seen? You've got these traditional pit bull attorneys. I'm thinking they can't be too enamored with this process. It's cutting into their business. So, what sort of response have you seen in the legal community to Solagree?
It's been fascinating. I thought when I started this, I was very nervous to formally roll this out and say, I'm here. This is what we've been doing because I was nervous about what my colleagues, not just the ones I know, but in the country would think about this. I had no idea how thirsty attorneys were for a solution in their own practices. It has been so validating to be around the country talking to so many practitioners say, thank you, finally, this is it. This is the solution. This is the answer we've needed. So a lot of validation. However, yes, there are some old school attorneys who simply don't want to learn about this. They're afraid of it. They feel that it's a threat to the way they do things, and quite frankly, sometimes it is. And that's okay. We don't we don't want that to be the way people go through this. We want to disrupt that mentality and that way of thinking. Those attorneys are going to learn, though, that millennials and Gen Z and folks going through gray divorce, they do not want that old school type of battle. You know, they're not going to be happy being represented in that fashion.
No, for sure. Amanda, this is great. I really appreciate your sharing the Solagree method with our listeners. Is there anything I've missed? And if not, how can people find out more about what Solagree is all about?
Yeah, thank you. I think that we've covered a lot of information today. I would say if you want to reach out, first of all, the website is Solagree, which is Solagree.com, www.solagree.com. My email address, you can email me directly and I won't charge you by the hour to respond. That's my gift to your listeners and everyone. I don't do that for Solagree. So it's simple. It's Amanda at solagree.com. The name Solagree is meant to evoke something that doesn't sound like anything legal whatsoever. That was the advice of a lot of different professionals. And, that was hard for me to make a switch
Yeah.
from, Mason and Smith attorneys at law to something that doesn't sound, but it is quickly becoming synonymous with a process that I'm very proud of. And I just really appreciate you giving me the opportunity to talk more about it.
No, I was happy to do so, Amanda, and congratulations to you, and best of luck to you and the adoption of the process as you continue to roll it out. Thank you very much for spending time with us today.
Yeah, thanks, Andrew, and thanks for all the good work you do out there. You're really fantastic. Appreciate it.
Thanks very much.
Thanks so much for tuning in to this episode of the Gray Divorce Podcast. To learn more or get in contact with your host, you can visit Andrew's website at transcendretirement.net. Also, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show, and we'd greatly appreciate it. Thanks again for listening, and we'll catch you in the next episode.
Information provided is educational only and should not be construed as legal or tax advice. Each situation is unique and should be discussed with your tax or legal advisor prior to implementation. Andrew Hatherley is not an attorney and does not provide legal advice. Information provided is financial in nature. Advisory services offered through Hatherley Capital Management, LLC. Divorce financial analysis services offered through Wiser Divorce Solutions, an affiliated company.